It's day 3 of the hearing in the case about same-sex marriages in the Supreme Court. Now, the Chief Justice of India yet again has made some very important remarks in the hearing that went on today for the third day. And he questioned, are two spouses who belong to a binary gender essential for marriage? That's what the Chief Justice of India, Chandrachud, said while the hearing went on today. Now, he also noted that the law has evolved significantly in the last 69 years since the enactment of the Special Marriage Act in 1954, which provided a form of civil marriage for people who did not want to follow their personal laws. Now, remember, at least 15 appeals have been filed with the Supreme Court in recent months, stating that without legal recognition, many same-sex couples could not exercise basic rights such as those linked to medical consent, pensions, adoption, or even club memberships. And the same-sex couples, the petitioners in this case, say that they have to face discrimination and disdain by the majority because their marriages are not recognized legally. Now, the Chief Justice of India has, of course, made very strong comments there. As you can see on your screen, Justice Bhatt also said that the Act provided framework for the concept of marriage, and the concept transcends temporary understanding and it's an evolving dynamic. Chief Justice of India, Chandrachud, said that the act of decriminalizing homosexuality contemplates same-sex marriage-like relationships, and he also importantly said that these relationships are not just physical but more of a stable emotional relationship. So those strong comments coming from the Chief Justice of India that are being welcomed by many, in fact even the petitioners in this case. Let's listen in to what all happened in the Supreme Court. Here are the highlights.
You are really asking us to read into the statute the expression spouses for really man and woman.
So does the underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct?
Because your principal premise is that when the legislation was enacted in 1954, the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage.
Absolutely.
Right?
And special categories.
You are giving Parliament was intending to provide an avenue to people beyond your religious, the religious governance of marriage, so to speak.
Yeah. There was also an aspect of endogamy.
Yes.
There was an aspect of endogamy which we cannot ignore.
So
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to be a very special category.
After 1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable relationship.
Because you go back and say,
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law. And surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
Let me put it bluntly.
The same sex as well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
That makes no difference.
The way which you are perhaps propounding is, this provided a framework, but that framework is of the concept of marriage. The concept of marriage transcends contemporary understanding to
it's an evolving dynamic concept.
To comprehend an evolving idea of
dynamic, very dynamic.
Looking at India, constitutionally and socially as well, we have already reached the intermediate stage. Right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship right?
Societal.
Which now is an incident of our constitutional interpretation.